Good afternoon. Today we are doing a seminar, a webinar on the Zulu royal dispute, and we're going to be looking at lessons we can learn from the royal dispute. My name is Kineile Mabapa. I am an attorney. I'm also an author of a book called Before, During, and After the Wedding, which is a book on marriage in South Africa. It looks at the legal implications of marriage in South Africa, and it covers all types of marriages, whether it be civil marriage, a customary marriage, or a civil union. It also looks into cohabitation and what are the challenges of each of the marriages that we have, as well as the marriage systems. So we're going to, as I said, we're going to look at the Zulu royal dispute. We know recently the Zulu nation lost its king, King Goodwill Zwelithini, and that after his death, one of his wives, Queen Mantombi Zulu, was appointed as the regent of the Zulu nation in his place. Subsequent to that, we also had two court challenges wherein his first wife, Queen Sibongile Zulu, lodged an application to the High Court wherein she challenged the marriages of the other wives. The king had 6 wives. So she is the first wife. She challenged the validity of the marriages of the 5 other wives, and she claimed 50% of the estate of the king, because if you are married in community of property, then the estate becomes a 50-50, it gets divided 50-50. The other thing is also she challenged the eligibility of Queen Mantombi to sit as a regent. That was not the only challenge. The other challenge that we had was the challenge by her 2 daughters, who challenged the validity of the will that was read out and said to be the will of the king. So as we were still surprised looking at those things, the applications, and thinking about what's going to happen, unfortunately, the regent herself, Queen Mantombi, also passed on. So when she passed on, we all know that there was a reading of the will, and she recommended her son, Mrs. Zulu, to be the new king, and we have subsequently heard that he's now the new Zulu king. So the disputes that were there, it seems as if they have now subsided. But nonetheless, whether they have subsided or they will still resurface, we can learn something from what happened. We might not be of royal blood, but we are also human beings. We also get married, we also die, and when we die, certain things happen. So again, as South Africans, and most of us being Black, we find ourselves in a predicament because we operate in 2 worlds. The one world where it's a civil world, we're looking at Western laws, and the other world is the traditional practices that we have, which is governed by customary law. Most of us would like to believe that no, we are modernized, we live in town, we don't subscribe to customary law. But so long as when you get married, for instance, lobola gets paid, and we celebrate, that is a customary marriage, and there's laws that apply to in that particular instance. So what we currently have is a clash between custom and civil law. Civil, I will refer to it as common law, civil law refers to marriage as monogamous. So it means that if a man marries a woman, he cannot go and marry another woman whilst he's still married to the first woman. So it is monogamous in that instance. And then we have customary law. Customary law allows men to marry more than one woman. And as Black people, we tend to enter into both customary and civil law. Let me share, because I prepared a presentation, let me share the presentation so that it gets easy for you to follow. Now, as I said, as Black people, we enter into both civil and customary marriages. And this is what the king did. His first marriage was a civil marriage, meaning he should not have married again, or rather he should have divorced the first wife in order for him to marry the other wives. The law as it stands, it invalidates his successive marriages, except for one which I will talk about later. And from a common law perspective, if you look at it strictly from a common law perspective, we would say that the king committed bigamy. But from a traditional perspective, remember, customary law is recognized in South Africa. It is also recognized in the constitution. So as part of Zulu culture, and it's not only Zulu culture, but Pedi also practice this. The Botswana, Xhosas also practice this. Our culture allows for polygamy. Now, the king in Zulu culture, the king almost always marries more than one wife. In our case, the late King Zwelithini married 5 more wives, in addition to Queen Sibongile Zulu. And one of those wives is referred to in English as the candle wife, and that is Queen Mantombi. Now, if you look at our history, marriage in South Africa has always been polygamous. And then entered the colonialists, and Jan van Riebeeck and his friends. They found our way of doing things repugnant. And then they started imposing their own values, because white people did not get married to more than one wife. So they said, no, this thing of polygamy, it can't work. So people are going to have to marry one wife. And as a result, Black people were forced to marry 2 times. The first time in terms of customary law, because we believed in our customs and we respected our customs, and we wanted to satisfy our traditions. Now, the second marriage would be civil, because we wanted to comply with the law. Okay, so initially our getting married twice was really a necessity. A lot of people ask, why is it that we get married twice? And this is the reason why we're getting married twice in terms of civil and customary law. It's no longer necessary for us to marry twice. Right now, we're doing it because we want to. And the reason is that as from the 15th of November 2000, a new law came into effect. That law is called the Recognition of Customary Marriages Act. And for the first time in South Africa, that law recognized customary marriages as marriages. Before then, customary marriages were regarded as customary unions. And the implications of the non-recognition is that a man would get married to a woman, for instance, in terms of customary law, and then later find another woman, get married to her in terms of civil law. What would happen is our legal system would recognize the second marriage rather than the first one, because the second marriage would be done in terms of common law, in terms of the law of the country, and that took precedence over customary law. But as from the 15th of November 2000, all customary marriages which were in place before the act came into effect became valid marriages. And after that, if you enter into a customary marriage, your marriage is valid. However, the fact that that law came into effect didn't mean that we stopped having challenges, because of the fact that we have three types of customary law in South Africa. There's the customary law, which is codified, which is written law. Then we have academic customary law, and this is normally what we find in books and what is taught at universities. Okay, and then we have the third one, which is living customary law. And this is the actual practice. These three things are normally not in sync. So you would find that the law says one thing. I will give an example with the Recognition of Customary Marriages Act. It makes provision for customary marriages, but it forgot to make provision for customary marriages, royal customary marriages, because royal customary marriages are different to, marriages of commoners like us. For instance, it is not the practice for a man to marry what is called a candle wife, but it is practice for a king to marry a candle wife. A candle wife Mosadi was chab. This is the wife that would be married in order to raise the future king of the particular nation. Okay, but there's no provision for it. The fact that there's no provision for it in the law does not mean that that practice is not supposed to continue, because it is continuing, and that is what the late King Zwelithini did. Okay. The implications for all this is that the written law is often referred to in books, and then the lived customary law is what we do on a normal basis. We just simply disregard what is written in books. We disregard what is written in the law and continue doing what we've been doing. Now we get caught up in the system. King Goodwill Zwelithini was caught up in the system. Most of us Black people, we caught up in the same system because we go and follow the common law path, and then later on we go and follow the customary law path. And normally these two clash. Now, when there's a clash, courts are often approached to referee between the two parties. And what normally happens is that the court will use written law, written customary law, to be able to make the determination, except in very rare circumstances. For instance, there's a case of Mayelane versus Ngwenyama, where a man had gotten married to two wives. He had a customary law wife, and then he had a civil law wife. When he died, the customary law wife went to report at Home Affairs to get a death certificate, and to her shock, she found that somebody else had already gotten the death certificate, and that person was recognized as the wife to her husband. She didn't know married. His family also did not know that their son had gotten married to somebody else. So the option that they had was to go to court. And when she got to court, she said, you know what, in terms of my culture, if my husband had wanted to marry a second wife, he was supposed to consult me first. I would have to give consent to the second marriage before he can marry. So the case went up to the Constitutional Court, and the justices then decided, you know what, we don't know customary law. For us to be able to find, to be able to make a decision, we need to get an understanding of what customary law says as far as marriage of the second wife. And they called the traditional authorities, they also called academics to come and give them the real practical lived customary law The people who approached the court were from the Tsonga Shangan tribe. So they talk about what is their experience in their particular nation. And the court, after having had all the evidence, then came to the conclusion that Tsonga customary law requires that for a husband to marry a second wife, he has to get the consent of the first wife. So in some instances it is done, but in most instances, as I said, written law is what is considered. So the reality is that as Black people, we are caught between a rock and a hard place, which means that we need to have an understanding of the law, both the common law and customary law, and make sure that we work within the confines of these two laws so that we don't find ourselves falling foul of the law. Now, I will now get into the applications that are made by the late king's first wife and her daughters, starting with the application that was made by the first wife. The first of her claim was that she got married to the king in terms of civil law, which meant that all subsequent marriages that the king entered into were not valid in terms of the law. So the current situation, as I've explained earlier, if you get married in terms of civil law, you are not supposed to marry again, whether it's in terms of customary law or civil law. So that is the implication. If you look at it purely from the civil law perspective, then it means that the Queen was correct to say that the other marriages were invalidated, except for one marriage, which I will talk about just now. So now the other thing that she claimed was that her marriage, she got married in terms of the Marriage Act, and her marriage was in community of property. I just want to make a clarification there. At the time she got married in the 60s. Black people did not get married in terms of the Marriage Act, so that is incorrect. Black people were married in terms of the law called the Black Administration Act. And that act, when you got married in terms of it, Black people's marriages were out of community of property, not in community of property. I will give an example with I think you will recall when our late president, Nelson Mandela, divorced his late wife, Winnie Mandela. It became clear that these two were married out of community of property, and it's because they were married in terms of this law. As I say, Black people were married out of community of property automatically, which would mean the Queen's marriage was initially out of community of property. Now, it's only recently, I think last month, April, if not April, March, that the Constitutional Court made a decision in the case of Sithole versus Sithole, wherein a woman had gone to court to ask for intervention because she was also married in terms of the Black Administration Act, which meant that her marriage was a marriage out of community of property. And she was going through a divorce. It was going to disadvantage her. And then the Constitutional Court held that marriages under the Black Administration Act would now be in community of property. They ruled that it was unconstitutional that they remain out of community of property. So that would then mean that the Queen's marriage, which was originally out of community of property, would now be in community of property as a result of the Sithole case, not as a result of the marriage that she entered into. So that is just for clarification, but at the end of the day, her marriage was now under community of property. She also laid a claim to 50% of the estate. So if the Sithole case had not happened, should not be entitled to 50% of the estate, because if you're married out of community of property, it means that when the marriage ends, whether by death or marriage, you don't necessarily get anything from the marriage. At least if it ends through death, you will be able to inherit. But if it ends through divorce, you get nothing. So, but now that she's married in community of property, the consequences of marriage in community of property would be that she would be entitled to 50% of the estate. Now, the third thing is the issue of the status and eligibility of Queen Mandombi to become a regent. Remember earlier I said that there is one wife whose marriage is not invalidated, and I was referring to Queen Mandombi. Queen Mandombi was the council wife. When she got married, she was not married. She was the wife to the late King Zwelithini, but she was not married by the king. And this is where the trick is. She was married by the Zulu nation, not the king. So the fact that maybe if the court had declared the first wife of the king, the one whose marriage was valid, did not invalidate Queen Mandombi's marriage, because she was not married by the king in his personal capacity, but was married by the Zulu nation. And the reason she was married by the Zulu nation, part of it was that she would then give birth and raise the future king of the Zulu nation. So the reason for the marriage of a candle wife, and the reason why she's married by the nation, is because of that fact that the king comes from that wife, not any other wife. Okay, so her status as a wife would still have been valid, even if the court had found that the other marriages had been invalid, purely because of the fact that she was married by the Zulu nation and not by the king. And this is not only a practice of the Zulu nation, it cuts across the various nations. I will give an example, for instance, which something that happened this year. We had in Limpopo, we have the king of the Bapedi nation who died, passed away this year, King Tulare. In his case, he had already 2 wives, he had children, but none of these wives could be regarded as the council wives. And his children, the children that he has, cannot step into his shoes. Okay, so what has subsequently happened is that you had the mother of the late king, Queen Manyaku Tulare, being installed as the regent. So currently we're having the mother of the late king sitting as the regent of the Bapedi nation, which is basically what Queen Mandombi was installed to do. You'll remember that before her death, she was sitting as the regent of the Zulu nation. And just to clarify, a candle wife cannot just be anybody, cannot be just a commoner. A candle wife is somebody from royalty. Just as much as Queen Mandombi, we both know that she's the daughter of the late King Sobhuza from Swaziland. Now, the Bapedi are saying that they are going to marry from, is it Lesotho? Yeah, from Lesotho. They're going to marry, the king has died, but they're going to marry a candle wife from Lesotho to be able to raise a king for Bapedi. Now, we know the king has passed on. Somebody's going to have to do the deed. And that person would be somebody from the Bapedi royal family who will do the deed with whoever comes in as the candle wife of the late king, and the child from that marriage will be the one that is will be able to take over as the king. And I'm sure you will see from this that customary law and civil law are just simply split. There is no way where they come together. Okay. So now if we now looking at the second court application, the daughters of the king, before I talk about this whole thing, I just want to indicate that the late King Zwelithini wrote a will, and part of what he wrote in the will is that if any of his wives challenged the will, then they would be disqualified from inheriting. And for me, I think that's why it makes perfect sense that the first wife did not challenge the will directly, but her daughters went on to challenge the will. I'm thinking the reason she didn't do that is because by just challenging the will, she would have invalidated herself from inheriting anything that he would have put in there. So now the daughters, they challenged the will and they said the will is invalid because when looked at the signature, they realized that the signature there is not similar to the signature of their father. But I don't know the truthfulness of that. But that's the reason why they challenged the will. So when you look at it, I looked at it and I was like thinking there could have been a better way to do this rather than to go challenge the will in court. We have, in our country, we have a process that we follow when somebody dies. When somebody passes on, we are required, the family, the wife or the family of the deceased is required to go to the Master of the High Court and within 14 days to report the death of the late person. And once that is done, an executor is appointed. The executor will then go on and administer the estate. Now, if the children of the king thought there was something wrong, fictitious with the will, what they should have done is simply to report to the master, because it is up to the master to decide whether he accepts the will or not. So the master would then have looked at the will and had made their own decision whether to accept the will or not. So if he accepted it, then he would appoint the executor to administer the estate. If he felt that there was something wrong with the will, then the master would then refuse to appoint the executor, refuse to continue with the administration of the will until the court instructed him to do so. Because then it was only then that they would go to the court and have the court make a determination. If they had followed that route, there would not have been so much turmoil within the Zulu royal family, and we would not have gotten to know that there was something wrong. So, and I think relationships within the family would not have been disturbed. As we saw, there were like two factions within the family, others demanding this, others demanding that. And that normally happens when somebody dies. So the other thing is, although the queen did not challenge the will directly, she made demands in her application. One of the demands was that the premier of the province published, she wanted him to publish the late king's assets, and she wanted the court to make an order for the executor to disregard the will of the king. Now, with regards to the publication of the late king's assets, I think there she was acting out of her jurisdiction, because it is only the executor of the estate who has the authority to collect all the assets of the deceased. and distribute them. So she did not have the right to ask for that, as if we look at the law currently as it stands. Now, also to order for the executor to disregard the will, that it would have been was this premature to ask the court to do that, because it is the master who has been given the authority to first get the will and make a decision whether the will is acceptable or not. And only after the master has made that decision would anybody be able to go to the court and then challenge the will. So again, I'm thinking there, she jumped the gun. So, but what are the lessons for us from this whole saga? The thing is, we are all going to die at some point. And us going to die, we cannot confirm how people are going to react to our death. And we're not going to, confirm how situations will turn out. I'll give an example. For instance, when the king got married in the 60s, his marriage was out of community of property, even though it was a civil marriage. But then when he died, at the time that he died, the Constitutional Court had made a decision that marriages that were entered into, which would include his marriage, by the way, under the Black Administration Act, would now be regarded as marriages in community of property. So he would never have anticipated that when he got married, but situations changed. Okay. Now, the other thing is death and grief can lead us to making decisions that cause tension and breakup of families. I think all of us, we know of people where somebody died, and especially the big breadwinner of the family, and the family disintegrated. Because they were fighting over the inheritance, they were fighting over this and that. Okay. So those things happen. We have no control over it. It's not all families where that happen, but we see it happening. I know I've seen it in my own family also. So what that tells us is that we need to have an understanding of the laws that regulate our lives. So we also have to consider estate planning. Both King Zwelithini did that, and the late President Nelson Mandela also did. King Zwelithini put his thoughts in a will, although it was challenged. We don't know if that challenge is going to proceed or not. I hope it doesn't proceed. But nonetheless, he put his thoughts down in a will, and his estate is going to be administered according to what he wanted. If the first Queen's challenge goes through and she wins 50% of his estate, then it means that the other 50% would then go to whoever is written in this will. Even if the court finds that the other 5 wives were not wives valid, their marriages were not valid, the fact that he wrote them in the will not change that. So they will share what is left of the 50% of his estate. Now, the other person who was able to do that was our late President Nelson Mandela. We know his first marriage to the late Mam Winnie Mandela was out of community of property. So when they divorced, there was no sharing of the estate. But when he got married to his second wife, that marriage was in community of property. What should have happened after he died is that his wife would have gotten half of his estate. But he wanted to make sure that his family members inherited from him, even his grandchildren. So he wanted to be fair, to ensure that his wife inherits and all his children. So what he did was clever about the allocation of his assets. He made an offer to his wife that his wife would not have, what's this, refused. So what he did, he said he's giving her certain assets. Remember, his wife was also, also had assets. She had assets in Mozambique. She was also independent, had her own properties and everything else. So he said, no, he's not going to claim his share in her assets. And then offered her certain items. What for me was a masterstroke is when he said he is giving an inheritance to her children with the late President Samora Machel, as well as the late President Machel's children, because he had 2 children before he met her. So, and remember, a will is read in front of everybody who inherits. So it would have been difficult for Graça Machel to say, no, I'm insisting on my 50%, when there were other people who were going to inherit. But if she insisted on her 50%, they would not have been able to inherit. Okay. The other thing was her own personal property that she came into the marriage with was not touched. So it was easy for her to accept the will of the late president. That is why he was able to leave things to his, even to his grandchildren. The other thing also, most of you would have heard that some of his children did not get money after his death. I think that was Zinzi Mandela, Zenani, yeah. And I think one of the grandchildren. It's not that he did not put them in his will. He did. He gave all of his children exactly the same amount. The only difference why these 3 did not get anything is that they got their share whilst he was still alive. So in his will, he allocated to them their share like everybody else, but indicated that they get it provided they would have paid back the loan that they received whilst he was still alive. So if they did not pay back the loan, that loan would then be paid off. Okay. So basically, he was able to cater for everybody. Even though they were unhappy, there was nothing that they could do because it was, they knew they had taken the money before he died, and he was supposed to be fair to everybody else. So again, what it teaches us, for those of us who are going to get married, it is important for us to check the marital status of, the person that we want to get married to. Because you might find that if you don't check the marital status, you're getting married to somebody who's already married, and your marriage would then be regarded as being invalid. You don't want that to happen to you. For those who are already married, it's also still important to check your status. I often say there are a lot of people, who, especially women, who go out there thinking that they are married, whereas in actual fact, as far as the law is concerned, they are not married. I will give you an example. I said earlier that when the Recognition of Customary Marriages Act came into place, the customary marriages that were entered into before that period, the 15th of November 2000, were now recognized as valid marriages. Okay. The result of that is that civil marriages that were entered into after, let's just say, for example, husband A married wife number 1 in, what's this, 1980, for instance. And then he then married wife number 2, 1990, 10 years later. Okay. Under the old law, the second wife's marriage would be the one that is recognized if she's married under civil law, as a civil law wife. I'm reminded of that show that was called Umfazwe Paper. Okay, so that the second wife would be recognized, and the first one, because her marriage was customary, the marriage would not be recognized. But after the Recognition of Customary Marriages Act came into being, it flipped things around. That first marriage, which was not recognized under the old law, now is recognized, and therefore invalidating the second marriage. And there have been cases where women have found themselves in the wrong side of the law, and their marriages were actually invalidated because of that particular fact. So it is important to check when you get married to somebody, if they were not married before, whether you're a man or a woman, the same thing happens. We've also had a recent case now here in Polokwane, where a couple got married, they both went their separate ways and both got married to somebody else. But their marriage, initial marriage, was a marriage in community of property. It was a customary marriage. So it was not, that marriage was not registered. So they went on, got married to other people in terms of civil law. The man died, I think it was like 2 years ago or a year ago. The man died. Guess what happened? That first wife, who had already been married to somebody else and gotten divorced, I think, was it gotten divorced or the man died? I don't remember quite well. She came back and said, yes, I'm the wife. The second one went to court and said, no, it can't be. She had actually gone on to get married, blah, 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 blah. I'm the legal wife. Didn't help. The court said, no, these ones, even though they went their separate ways, the reality is they were legally married. They never divorced. As a result, they're still married. And the marriage was invalidated. The second marriage was invalidated. The first wife walked away with the prize. So you can imagine what the implications are for the second wife. So it's important for you to check. And I always say to people, whilst you're both alive, it is possible to find solutions to the problem. But it is too late when one of you dies. There is no way that you can find a solution. The law applies, and the law is cold. It doesn't care about your feelings. It doesn't care that somebody actually went and gotten married and they were not together for 20 years. Okay, so the lessons for us is that if you look at the case of our late President Nelson Mandela, as well as the late King, you need to know your bargaining power with regards to your spouse and your children. I always say to people, there is something that your spouse really needs, that if you give to him or her, they will be able to let go of certain things. You need to know what is that. And with regards to children, it's important to, again, children and your spouse, you need to know their needs. You need to know their strengths and their weaknesses. And you need to make provision for those. For instance, I'll give an example. If you have a child below the age of 18, that child is regarded as a minor. If you pass on, the master has to appoint somebody to take care of your child, a guardian for a child. If you don't have a will, that is what is going to happen. But if you have a will, you will decide, you'll have control over who's going to raise your child. Okay. Now, the other thing is, when you have children, I often find when I help people with drafting their wills, a mother would come in and say, I have 3 children, so I've decided my children will get 33.3% each. And I'll ask, how old are your children? Do you have a child with a disability? Have they completed their education yet? And you'll find that maybe the last child is still at primary school. Maybe the other child has a disability. They are not going to be able to take care of themselves until they die. Then the third child, the oldest one, has gone through school. Maybe he's even working, he's a doctor, has a family, he's stable. So if you're saying you're going to give these 3 children, all of them the same amount of money, you're actually disadvantaging the other 2. Because the first one still needs to go to university, sorry, to high school and then to university. Okay, they need money for that. The second one with a disability, they need somebody to take care of them for the rest of their lives. So you cannot treat them the same as somebody who is already educated and is already working. Now, there's also parents who have children with a drug addiction. You know, if you're going to give the 3.3% of 10 million to a drug addict, where is it going to go? To drugs, to drug lords. So it's important, as I'm saying, you have to know your children, you have to know their needs, their strengths and weaknesses, and then make provision for them, either through a will or trust. When you do your planning, you really have to know how you to take care of your children. And the other thing is you have to have somebody know what you have put into place. They don't have to know the contents of the will. They don't have to know the contracts of your estate planning documents, but somebody needs to know if you pass on today, you have a will and where that will can be accessed. You don't want a situation where your estate is administered and then 10 years down the line, a will comes up. Yeah. So the other thing is you also have to put all of your documents together. One thing that I've discovered is that when people die, we don't even know the account number, what bank they used. So it gets very difficult. We have to go shopping to all the banks and ask, did this person have an account with you? If they had an account with you, tell us how much they had. And it becomes a challenge. It prolongs the process of administration of the estate. So if your documents are together and somebody knows where to find it, it makes the administration so much easier and so much faster. So the other thing is you need to review your plans from time to time when your situation changes and when the law changes. For instance, there's been situation where people have written wills. I know of a situation where a woman wrote a will while she was still married to her first husband. The husband abused her, they divorced. Then she later met somebody else. They got married in community of property. He was a businessman, a very rich man. The wife died. Now, the executor came to the husband and said, okay, so here's the will of your wife. And your wife says, I leave all of my assets to my husband. And guess which husband that was? The first abusive husband. And the second husband was very upset about that. He went to court, challenged the will, and the court said, no, there's nothing that we can do. That is what your wife has written. She's left the assets to the first husband. So, and they were married, so they were not married in community of property, they were married with accrual. So their husband had to give a certain share to the former husband. And guess what? When you are in business, you might be wealthy, but your business, your wealth might be tied up in the business. In real estate, for instance, you might not have cash. The possibility in this situation is that the second husband would have to sell some of his assets to be able to give money to the first husband, which is unfair. If the wife had changed her will, that would not have been the problem. And I'm definitely sure she would not have wanted her first husband to benefit from her after he had abused her. But she forgot to review her will, and that's the challenge. Now, the other thing, when I'm talking about changes in the law, remember I was saying earlier that when the late King Goodwill Zwelithini got married, his marriage was in terms of the Black Administration Act, which made all marriages between Black people out of community of property. But just a few days before his death, there was a change in the law. because the court made a ruling that all those marriages are now marriages in community of property. I'm sure if he had lived a lot longer, he would have changed his will. But unfortunately, he got caught up in that particular situation. So yeah, I think I will end the discussion here. And then if people have questions or want to raise comments, please feel free to do so. So in the absence of any hand, maybe people will ask questions later. You want to ask? No, I'm just saying. Okay. Oh, okay. I'm with my friend Zola in the room. Maybe I should.
Hello. Where's my mute button?
Hi. Hello.
I'm trying to find my.
Hello.
I'm
Yes.
still mute. Hey, Shu.
Hello.
Can you hear me?
Yes, I can hear you. I don't know if everybody can hear me.
Oh, okay. I can hear you.
Yes, we do.
All right.
All right.
I was saying I'm with my friend Zola, and she's asking me a question about fraudulent marriages, where women often find themselves married to foreign nationals. Isn't it? Yes. Yeah. Okay. So she's saying sometimes happens that somebody is married without knowing. Yeah. And it only comes out after their death when the family goes to report that this person has died, and then they get a death certificate saying this person is married, and they don't even know their husband, and it becomes a bit of a challenge. Look, those types of marriages happen. I think my advice to people often is that you need to check your marital status with Home Affairs often. It used to be in the past that it was easy. You could send an SMS to Home Affairs and ask, put in your ID numbers, and you'll get a response back to tell you whether you are single or you are married. But that option, I've tried it 2 months ago. It doesn't seem to be working anymore. But that would not help to walk into the offices of Home Affairs and do a check of your status, because it does happen. I know from experience. I nearly became a victim of that scheme. When I was young, there was a friend of my mother's. His child worked at Home Affairs. And she was part of the scheme wherein they would marry people. And I was approached to say, you know what, here's quick money. By then, 4,000 rands was a lot of money. It was almost like 40,000. So now we get 4,000 rands, we register you, you get married to this person. You don't even have to know them. Then you can later divorce. And I was like saying, hell no, it's going to cost me a lot of money to be able to divorce. So I didn't get into it. So some people, they enter into this thing willingly. And some people, they don't. So I'm saying the only solution currently is to look into your marital status. So because if you find that you're married and you know yourself not to be married, you can then approach Home Affairs, and then get the process of investigation going on. It unfortunately, it takes long. And this is one of the things that the Department of Home Affairs, recently, I think it was this week, Monday, released a green paper on marriage in South Africa. It is one of the things that is being considered. How Home Affairs is going to deal with it. Unfortunately, people only looked at one thing, the issue of polyandry. Women getting married to more than one man. But there is so much more in that white paper that people should be looking into, including this type of marriages. That's all I can say on the matter. So yeah, I don't know if there's any other so that I can continue after addressing the comments, and then we can close. I'm now using a small gadget. I don't know how to use the all other features. My laptop, something happened to it. It just went completely blank. So if anybody wants to raise an issue, just unmute yourself, speak, and then after that you can mute yourself.
Okay. Hi, Kineilwe.
Yes.
My name is Charles. Thank you for these deliberations you made. Is very much informative and eye-opener. I've just got one concern. There's quite a lot of things that are happening. Is it possible that this could be, shared on a public domain so that most of the people will get to know, because we are only few here. And I think this affects a lot of us in one way or the other. And how can we make, because my observation is that in our country, there's a lot of ignorance into little things that which at the end of the day, our eyes are opened at the last moment. Then we start, going up and down, like you were saying, the things that which you said, they're so scary. If you can look at them, just imagine having stayed with somebody for that long time, and once somebody who was the reason for her to be married for the second time has to benefit all. There are a lot of things that are happening out there. How can we, or how can you make this thing to go into a public domain? Well, I know most of the people might not be interested and to think, no, what is she talking? But I think it will help a lot of people. Thank you.
Thank you. Charles, I normally do seminars. I just stopped last year because of the COVID. But now I've decided to do the webinars, because the fact that COVID is here does not mean that the need is no longer there. So the other thing is, I've only started with this webinars last week, and I've had communications for each and every day. And it's because I'm only starting, I think. I'm still learning how to use this thing. But I'm sure that today we've had recordings. I hope that the recording will work, even though we got interrupted. And then if it's there, then I will be able to share. Unfortunately, yesterday's recording, there was no voice to it. I don't know what happened. So as I'm saying, I'm still learning. But then it goes back to the next thing that I wanted to say remember we had 4 webinars talking about the single marriage statute. This is the 5th one, which is we're just talking about the Zulu royal dispute. But I was thinking the same thing that you're thinking, that this should not be the end. So I'm planning on doing webinars on a number of topics. Marriage, for instance, on divorce, on succession, on estate planning, estate administration, looking at best interest of the child, issues of maintenance, care, support of children. And of course, feel free to make suggestions on topics that I could talk about, so long as they are related to family and estate planning. I have decided to focus on these 2. I don't do criminal law, I don't do other types of law, but I'm focusing on this thing because my interest is on building families and making sure that whatever we do, we leave good legacies for our children, rather than having them suffer because we made bad choices as adults. The other thing that I wanted to find out from you is what would be the suitable time to have these webinars, as much as the suitable dates. I just chose random dates, but I'm not sure if these dates would be suitable for most people, and also whether the times are suitable, because I know sometimes people call me after the webinars are complete and they would say, we try to log in and I would say, but the webinar ended a while back, So yeah, I'm from my side, I'm trying to do something. The other thing that I'm planning on doing is videos. I've consulted a friend of mine who's a photographer, videographer, and asked him, whether he can help me with that. He's agreed. We just have to agree on issues of fees, and then I will be sending out the videos on a regular basis. It was just a matter of me getting used to it. I will welcome any suggestions from your side. I see Maggie has raised a hand. Maggie, I think you can unmute yourself and then raise your question.
Okay, thank you so much for the information. Thank you so much. It's really an eye-opener. I just wanted to find out about the law that you said it has been passed in March, where you say if you were married in customary law, according to customary law, that means you are married, but you didn't go to Home Affairs to sign, but you are married. Then since March this year, it has been changed to be, it's regarded as civil law. It's like you are married in community of property. Is it what you're saying, if I heard you well?
Not exactly. The law that I was referring to is the Black Administration Act, where it's an old law. It's no longer applicable. The law was the law that deals with customary marriages. It's called the Recognition of Customary Marriages Act, and it came into effect on the 15th of November 2000. And when it came into effect, it recognized all customary marriages, whether they were entered into before or after the coming of that particular act. I don't know if you're now getting clearer.
Okay, yes, it is.
No,
Can I ask?
What happened last month is not the law. It's a case. It's a decision that was made by the Constitutional Court. That decision saying those people who are married, in terms of the act, the act that I'm talking about, that is no longer applicable, the Black Administration Act. Remember, that act was saying Black marriages would be out of community of property unless they had entered into an anti-nuptial contract, making it in community of property. Okay, so the case that I'm talking about is the Sithole versus Sithole case, where the court said it was unfair. That law was unfair on people, Black people who got it during that period. And it had negative consequences to women, especially, who found themselves in a situation like in the case of Sitole, she would have lost everything because of the fact that she was married out of community of property. The bad thing about getting married out of community of property, excluding accrual, is that what you get into the marriage with and what you acquire during the marriage, when the marriage act, you end, you live with it. So if you came with nothing in the marriage, you acquire nothing in the marriage. When you live with nothing. That's the implication. But the reality is, often when people get married, you might have come with nothing financial, but it's not that you are sitting in the marriage and you're not contributing anything. I'll give an example. Often it happens that in the past, doesn't happen that much now. You would find that people get married, the husband would say to the wife, stay at home, take care of the children. Now the wife would be at home taking care of the children, taking care of the house, taking care of the husband. She does not bring in money into the marriage. Okay. It is the husband who brings in money. She administers the money and makes sure that everybody is taken care of. Now, when the marriage ends, and sorry, before I talk about the ending of the marriage, what would then happen if they are married out of community of property? The man, of course, will take the money that he makes, buy property, buy whatever, and invest in it. And it will all be in his name. So if it is in his name, when the marriage ends, he walks away with everything and the wife walks away with nothing, as if she did not contribute anything. And that's the reason why the court found that no, this marriage system that was put into effect by the Black Administration Act was unfair on women. And then it said the marriages would be in community of property. I don't know if I've answered your question correctly. Are you happy with the answer?
Yes, I understand it quite well now. Can I ask about, I just want to be clear, if now people get married, and then, but they don't go to magistrate to sign, they get married, what is it regarded as and what is the implication?
Okay. If you get married in terms of customary law, the Recognition of Customary Marriages Act says you must register your marriage within 3 months of the marriage. But the same law says if you did not register it, your marriage is still valid. The only implication is if you've registered it, it's the same as a civil marriage because you'll have a marriage certificate. But if you have not registered it, you are at a disadvantage. I get you know that, for instance, when I'll give an example again with the husband passing on. What normally happens is his family will in most instances, not always, they will come and say, you killed our child, and then they want to take away the assets of the marriage. So if that happens, you are at a disadvantage because then it means you have to then go to court to assert your rights as the wife. And it gets very difficult. You know, can you imagine you've just lost the husband. Now you have to run to court. And court is very cold. Eh? You have to run to court and say, instead of mourning for your husband in peace, now you have to fight with his family. That's the one disadvantage. The other is that when the relationship ends, you will find that whoever finds it to their advantage would then say that, no, we were never married. Now, if somebody you've been married to says you were not married and you don't have a marriage certificate, the next best thing for you to do is to go to court and to prove that you were married. It's a disadvantage. Sometimes people don't even have money to be able to go to court, because when you go to court, you have to pay your lawyer fees, isn't it? So it becomes a challenge. The best thing to do is to register your marriage. And I always say, especially to women, I'm not saying guys do not have this problem, but it is my experience that women are the ones who have a problem. So I always say, whilst you're still in love, whilst he's paying love for you, drag him to the Department of Home Affairs, you register your marriage. The same thing to the guys. Whilst things are still nice, go and register. Because once you start having problems, nobody is going to agree to go to Home Affairs to register your marriage. And Home Affairs at this current moment, they do not want to register a marriage where it's only one person who comes in. And remember, when you register the marriage, it has to be you, the husband, somebody from the husband's family, and somebody from the woman's family. The best way to do this is if both families are still enjoying this relationship. Yeah. Okay. Then there's two, I think there's a question here from Jabu. He's asking, the rural home, can a husband put that in? And then the other is, can a husband leave the rural family home to his wife if she was living in it and there is no husband's parents or siblings if he's married out of community of property with accrual? Okay, so two questions in one. The rural home falls under the jurisdiction of the traditional authority. So if you are divorcing, for instance, we do not count that as property, because the property that we count is property that is registered with the deeds register, the registrar of deeds. The one that is in the rural area, as I said, falls under the traditional authority. It is not owned by you, but the traditional authority gives you permission to occupy. Okay, so it does not fall under the jurisdiction of the court. However, you can leave the property to your wife if you so wish. You can do that through the will, or whilst you're still alive, you can go to the traditional authority and then ask them to change from the ownership from you to your wife. It's possible to do that. The other comments, I'm getting comments that 5 o'clock is a bit early. Maybe we should start at 6 o'clock. And there's support for this suggestion. I think I will concede. I was afraid of starting at 6 because I thought 6 would be a bit too late. So, but if people are fine with 6, and also from the comments that I normally get from people, it looks like people are able to log in just before 6. So maybe one should start at 6 o'clock. I don't have a challenge with it. So far, I didn't ask you, Charles, if Charles is still in, whether I covered his question to his satisfaction.
Hi,
Charles,
Kinele.
you're still in?
Yes. Yeah, I think you have done well on that one. You covered it well. I heard you saying that you will consider videos and all that. This is the information that which we need, and we will also consider inviting our pastors as well in the preceding meetings that are coming, because I think they are the ones that, in a way, even not legally, they adjudicate such disputes in the churches. You know, people will run there first to get advice, and if the pastor is not well conversant with what the law says, they will often say, let's pray, which is a good thing, but also the legal part of it needs to be taken into consideration. because
Yeah.
because it is tough out there. We do
Yeah.
have a lot of, even us, we do have some lot of questions. I don't know, some of them we are afraid to even ask them here. Maybe some of the audience is part of family who would say no, you hear he's asking about that, you know. I don't know if we are allowed even to, you know, to forward questions to you on a private platform. Like if we don't feel comfortable to ask certain things just here, I don't know, but it is a very important topic that you are tackling. I don't know where you, I think you are FNB. How can we help you?
Yeah, and like FNB, I charge when you start wanting personal advice.
Well, you know,
Um,
if I would get charged and get information that will help me tomorrow, so be it.
yeah. Okay.
Hmm.
All right. Yeah, you can do so. My and unfortunately, my laptop just gave up on me. But then I can give you my contact details. You can call me at 076 884 1842.
You were too fast for me.
076
076, yeah,
884
884
1842.
1842.
Yes. My email
Okay.
address is
Wo-
info.
Would you want to write it on the chat? Maybe it will be easier.
Oh yeah. Yeah, maybe I should. Maybe I should
Mm.
do that. This thing also is giving me a bit
Technology.
of a challenge. Oh,
Technology.
yeah, no.
My
This one,
BBT, born before technology.
yeah. Hey, you got me there. You got me there. Okay. I'm born with what again? Yeah. I've just sent my email and I'm sending my phone number.
Okay.
Okay. So those are my contacts. And as I said, people can make suggestions on topics. I've just given you a broad outline of the topics that I would be talking about. Maybe I'll just recap: marriage, divorce, succession, estate planning, issues on the best interest of the child, like maintenance, care, and support of children. So if, say, for instance, around marriage, you want to find to know a specific thing around marriage, for instance, like your antenuptial contracts, you can suggest that make a topic on antenuptial contracts, and I would do that. So, and generally, if it's videos and webinars, it would normally be free. But as if somebody wants specific advice, then they would have to pay for it. Yeah, I think as far as I can see, there are no longer any questions, and we're now past, it's more than an hour that we've been together. Yeah. So, oh, there is a hand. Edwina?
Yes, hello. Good evening, everyone.
Yes.
Thank you, dear, for the
Yes, Edwina.
topics. I just want to add also, I'm not sure if you cover it or you can cover that one. Those for us Catholic who are just married in church and we are not married at the home affairs. How the laws deal with that in case one of the spouse is gone.
All right. I think it's something to
Thank you.
consider. All right. Okay. So I think we say goodbye to each other. Those of you who are on WhatsApp, I have your details on WhatsApp. You can send me a WhatsApp, and we can talk about whatever topic you have in mind. Thank you. We've come to the end of the session. Yes, and then I will communicate about future videos and webinars. Bye.
Bye. And thank you.
Bye-bye.
Thank you so much.
Bye.
Bye. Thank you so much. Have a great evening all.
Thank you.
Bye.
Bye, Kinelia. Thank you so much.
Bye.
Thank you. Bye.
Bye. I have